Courtrooms are nothing new for police officers, but what happens when they are the ones who have to take the stand and are pronounced guilty? Here are a few different cases of dirty cops reacting to their sentences in court.
Would Miss Potter please rise? I'm now going to read your verdicts.
This is Officer Kim Potter of Brooklyn Center Police Department, Minnesota. On April 11th, 2021, 20-year-old Daunte Wright was pulled over for an outstanding misdemeanor warrant against him. During his arrest, Officer Potter mistook her pistol for a taser and fatally shot Daunte. The footage shows what happened on the fateful day Daunte Wright was shot.
No, you're not doing that. No, you just not, bro. No, do Oh, wow.
Yes! I hit the wrong I shot him! Oh my God!
Okay, Kim, sit down. Okay.
Turning around on the red and you repeat your first three.
3-5, we got shots fired. Start more units, please. We're going to need additional units to Noble and 63rd.
Daunte's death sparked national outrage, and soon protests and demonstrations erupted throughout the United States. In the widely televised and broadcast court trial, a sobbing Kim can be seen taking the stand as defense lawyer Earl Gray asks what happened that day.
And by looking at his face at that point in time, what did you interpret it to mean?
He had a look of fear on his face. It's nothing I'd seen before.
Did you say anything when you saw this? What did you do?
We were struggling. We were trying to keep him from driving away. It just went chaotic. And then I remember yelling, "Taser, taser, taser," and nothing happened. And then he told me I shot him.
Can you proceed, or you?
Yes, it's fine.
Okay. After the driver said you shot him, do you remember what you said, or do you? If you don't remember, did you look at the video and see what you said, or do you actually remember what you said? I guess is my question. Not with help from a video.
I don't remember what I said.
And what do you remember next, if anything?
They had an ambulance for me, and I don't know why. And then I was at the station. I don't remember a lot of things afterwards.
Do you remember saying something about prison?
No.
After various testimonies, the jurors deliberated for over 27 hours, spread across 4 days, and finally reached a verdict. Judge Regina Chu announces the verdict as a stone-faced Potter listens.
Members of the jury, have you arrived at a verdict? Okay. Will the deputy please retrieve the verdict forms and provide it to me for review? Would Miss Potter please rise? I'm now going to read your verdicts as it will appear in the permanent court records of Hennepin County. In the matter of State of Minnesota versus Kimberly Potter, court file number 27 CR 217490, we, the jury, on the charge of manslaughter in the first degree while committing a misdemeanor on or about April 11, 2021, in Hennepin County, State of Minnesota, find the defendant guilty. And the verdict was agreed to at the hour of 11:40 a.m. and signed by the jury person on 12/23/21. The verdict on count 2 is we, the jury, on the charge of manslaughter in the second degree, culpable negligence on or about April 11, 2021, in Hennepin County, State of Minnesota, find the defendant guilty. And that verdict was agreed to at 10:30 a.m. on 12/21/21. Members of the jury, is this your true and correct verdict? So say you one, and so say you all.
Yes.
Kim Potter was found guilty on 2 counts and was sentenced to 2 years in prison. She was released in April 2023. The killing of Daunte Wright brought into light the fault lines that have always existed in the police training. Police officers should be held against high standards, as seemingly small errors on their part can lead to catastrophic consequences.
Let me just plea and get it over with for everybody. Plea to something that I absolutely do not feel good about, but I don't want you to try to send me to the penitentiary for years and years. If you can sleep with it, I can sleep with it.
This is Todd Pate, former sheriff of Breckenridge County, Kentucky. On March 8, 2019, he was arrested after he ran his car over 4 people. His blood alcohol level was twice the normal value, and he was charged with multiple felony counts. With a possible 15-year sentence in sight, the former sheriff agreed to plead guilty and is in court today for this very purpose.
At this time, is it your desire to change your plea from not guilty to guilty?
Do I have to answer that yes or no, or can I make somewhat of a statement? That
is a yes or no answer, sir.
Will I have the opportunity to say anything further?
If it is your intention to change your plea from not guilty to guilty, then I will take your plea, and certainly you'll have an opportunity to make any statement that you want to make. But if it is not your intent to enter a guilty plea at this time, then I'm going to set your case for jury trial, and you're going to stop wasting my time and everybody else's time this afternoon.
Ma'am, I'm not trying to waste your time.
And your intention to enter a guilty plea at this time or not?
No. Why am I wasting your time, ma'am?
What is the Commonwealth position at this time, sir?
The judge is visibly annoyed at Sheriff Pate's sudden 180 and asks the prosecution what they would like to do now. The prosecutor demands that the sheriff's bond be revoked.
Your Honor, we moved to revoke the defendant's bond at this time. We took part in a lengthy mediation. We agreed to continue this case 2 months to enter this plea today. I think we've inconvenienced the entire court system by canceling a pretrial date and continuing this matter for 2 months for him to resign from office. So we moved to revoke his bond at this time.
All right. Mr. Vowles, would you like some additional opportunity to meet with your client this afternoon before we proceed at this time?
I don't believe it'd do any harm. I'll make it very, very quick. I know we've already delayed the court, and I'll report back within a couple of minutes.
All right, I'll give you another 10 minutes with him. All right, thank you.
The court meets after a brief recess, but apparently things haven't changed much in Pate's mind. The disgraced sheriff wants to go on a lengthy rant, but the judge is in no mood for such theatrics.
And so at this juncture, so that the record is clear, I have previously been tendered executed documents by Mr. Pate that have been likewise signed by his attorney and by the Commonwealth. It is my understanding that through felony mediation that an agreement was reached, that agreement was subsequently reviewed with the victims in this case as well, and that the purpose for today's hearing was to enter that plea consistent with those executed documents. Perhaps I should have directed my questions first at you instead of Mr. Pate. At this point in time, what is Mr. Pate's decision with respect to proceeding forward with entry of his guilty pleas?
So I believe he's still under oath, and I believe I'll just let him answer that question of the police report.
All right. So, Mr. Pate, what is your position today with respect to entering a guilty plea here, consistent with the executed documents that have been tendered to me?
Can I say a few things,
I need to understand what it is that we're doing here today, Mr. Pate.
Yes, I had every intention of coming in here today and entering a guilty plea based on the mediation that we had. It's very difficult for me to enter a guilty plea to felony-related charges that I've been in law enforcement for 25 years, and never have I ever charged someone with felony charges on a situation pertaining to this that was similar to this.
If I may interject, just if you intend not to enter a plea, don't say very much about the case, because what you say here under oath will be used against you. I'm not trying to tell you not to say whatever it is you need to say, but also want you to remember that if you don't ultimately plead here, whatever you say, I would think that Mr. Chambers will definitely use against you in any further proceedings. Okay?
Pate is given a final warning by the judge to contemplate entering a guilty plea. It's crucial to highlight that Pate is confronting severe felony charges such as DUI, assault, and fleeing the scene of an accident, far from some minor misdemeanors or petty violations.
You know, it's difficult for me to enter a guilty plea for a lot of reasons, and I don't want this court to think that I am trying to minimize, take away from, or deflect any responsibility that I had in this situation that occurred. This was never an assault first case. Should have never been an assault first case, but it became that, and it became that to push me in a direction to take a plea. I'm willing to take a plea, but I now understand how some people feel. I've defended the court system many, many times, and still do, but I feel like I'm being very much bullied into doing something that's not right. Now, the gamble is big.
Sheriff Pate accuses the prosecution of holding a grudge against him and goes on a lengthy diatribe as his counsel holds head in his hands, dismayed at how his client is jeopardizing the plea deal that all parties had agreed to.
But it's hard for me to lay down and plead to felony charges that don't apply.
So I think we are back, Mr. Pate, and probably should have stayed in the place where we started. Again, I wanted to give you an opportunity to have further discussions with your attorney.
And I'm sorry, ma'am, for doing this. I'm sorry for
I think we're back to where we were before. Is it your intention today to enter this guilty plea? And I think we're at a yes or no place at that.
Can I say one more thing? I think everybody in this room wants this over with. And if I could address Blake, I hope you learn from this case I'm not mad at you. I'm not in any way upset with you. Not that it matters. Okay.
This is either a yes or no. Are you going to enter your plea?
I guess everybody thinks it's funny.
Well, certainly not the people who I think are here with you today.
I know they don't. I've broken everybody's heart. But it's hard for me when I see Mr. Chambers sitting over there smiling. Let me just plea and get it over with for everybody. Plead to something that I absolutely do not feel good about, but I don't want you to try to send me to the penitentiary for years and years. If you can sleep with it, I can sleep with it.
Okay.
And this is probably unusual, but let's do
At this point
it.
in time, I think we're done.
Sheriff Pate finally almost pleads guilty, but now the judge has decided that enough is enough.
At this point in time, I'm going to sustain the Commonwealth's motion to revoke his bond. He's going to be taken into custody today. We will come back for further hearing as to whether or not to go forward with this plea or to set this case for trial.
Pate's attorney makes a last-ditch effort to save his client from going to jail, but the water has passed under the bridge.
Your Honor, if I may speak to Mr. Chambers' motion to revoke the bond.
I've already ruled. I've already ruled at this point in time.
Ma'am.
We're done at this point in time, other than setting this for further hearing.
Sheriff Pate's fall from grace was witnessed by the entire country. He finally pleaded guilty to all felony charges. He had to resign from his office and had to serve 75 days in jail as part of his plea deal.
I'm asking all this so that I have the opportunity to watch my son graduate from high school, my daughter who's getting married, so that I can be there for her.
Welcome to Pike County, Ohio, where Judge Patricia A. Cosgrove is about to give verdict in trial of former Pike County Sheriff Charles Reeder. He has been indicted on 18 counts, including theft in office, tampering with evidence, and racketeering. The courtroom hears in silence as the judge tears down Sheriff Reeder's corrupt tenure.
Be seated, folks. We are here today for sentencing in the case State of Ohio versus Charles Reeder.
Sheriff Reeder, while sobbing, gives out a long testimony, pledging for leniency.
I stand here before you today to take accountability for my actions. As a sheriff of Ohio, I should, I shed bad light on the office of sheriff. I can only ask that my staff, their families, the community, and my family who is here today will forgive me for the undue stress I caused it. For this, I'm terribly sorry. I stood in this court on September 24th and pled guilty to the charges against me. To accept responsibility for my conduct. That day, within minutes, everything that I've worked for professionally and honorably for 25 years was stripped from me. With nobody to blame but myself. My staff and I had united with the community, had a partnership and trust. They truly believed in us as a unit, as a whole, and I betrayed that trust. If I could go back and change it, I would a million times.
Sheriff Reeder begs the judge for another opportunity at life, since he is greatly remorseful and wants to mend ties with his family. He also begs the judge not to send him to prison since his father has COVID-19 and is battling for his life in Columbus, but the judge seems unmoved.
I am a good person who made bad decisions and choices. I can continue to be a productive citizen in this county and be in the community with the love that I have for my family, my friends, and my neighbors. I'm asking all this so that I have the opportunity to watch my son graduate from high school, and attend college this year. My daughter is getting married in October so that I can be there for her. And my wife, so that I can be a husband that I haven't been in 25 years due to my career. I've just not been there. Given the opportunity, I would be able to spend the time with my mother and my father and continue to be there for them when they need me. In the last years of their lives, as I've experienced this week with my dad, when 2 days ago I thought that I had lost him.
The judge then asks Sheriff Reeder why he committed those crimes in the first place. To this, Reeder replies that he took the money from drug dealers, the bad guys. Reeder tries to persuade the court he is like Robin Hood, stealing from the rich drug dealers to give back to the community.
The big question I have, and is on everyone's mind, I'm assuming, is why did you cut open these evidence envelopes and take the money out, and then in some cases you put it back, although you were caught because the envelopes had been unsealed and sealed again improperly, and the denominations did not match what was taken at the crime scene or from those individuals. I guess, why did you take the money?
I took the money, and mind you, this does not excuse it, but from drug dealers that took it from parents of very poor people in this county. That money, regardless of what the state and what the media has claimed in the past years of a gambling problem and that money being used for gambling, was used when there was a tree planted in the name of the Shelton boy. It's at the entrance of Western High School to the left as soon as you pull in. Nobody could pay for that tree. Nobody offered to pay for that tree. A drug dealer did. When schools had cheerleading or pee-wee that had car washes and such, I would have our cruisers taken down there. My men and women did not make good money, so some of them would give them $2, $5. I took money from that and I provided it to those people.
The judge then gives Sheriff Reeder and the courtroom a piece of her mind. She begins to remind Sheriff Reeder of all the suffering his corruption has caused to the people of this county.
Here's what I want to say. You've been in law enforcement for 24 years. Whether you are a sheriff, whether or not you're a sheriff's deputy, whether or not you're a prosecutor, whether or not you're a defense attorney, or whether or not you're a judge, you choose to be in this profession. We see horrible things, multiple deaths as you have, deaths of babies, torture of old people. This court personally has had to sentence a number of people to death, impose the death penalty. We all choose our profession, and we have to conduct ourselves with integrity so that everyone trusts us. Now, no person is good or bad, but you had an obligation, Mr. Reeder. The sheriff's office, like every other PERS entity, has a free counseling program. In other words, you could have sought free counseling at any point in time for your conduct. It cannot be underestimated the damage that you have caused to the citizens of Pike County, to law enforcement who every day get up, face the same sort of stresses that you do. They go home at night, they get up in the morning, their family, they don't know if they're going to come home. The sacrifices that these men and women make, I think you made a mockery of them. I could have imposed a much greater sentence than I have. As I said, I've taken into consideration some of the mitigating factors, but punishment is appropriate. To sentence you to, I consider the minimum. However, to sentence you to anything less than 3 years in prison would demean the seriousness of the offense and not adequately protect society from future criminal conduct by yourself and others.
Reeder was sentenced to 3.5 years in lockup after taking a plea deal related to theft and corruption charges in 2021 while he was sheriff in the small county. Reeder pleaded guilty to 2 counts of theft in office, 2 counts of tampering with evidence, and 1 count of conflict of interest. Let's move to Denver, Colorado, where a handcuffed suspect, Anthony Waller, is appearing before a judge to face domestic violence charges. Waller is representing himself and is surrounded by police officers. One of them is Deputy Brady Lovingier, the son of Bill Lovingier, who headed the sheriff's department from 2006 to 2010. Deputy Lovingier has anger management issues, which are about to show themselves.
Investigation of false imprisonment, assault, third-degree assault, class 2 felony, and I think this would be as well. Thank you.
Yes, I'd like to object first. If I'm under investigation, I thought the investigation came first, then the arrest came.
As Waller looks back, Deputy Brad Lovingier grabs him by the waist and slams him headfirst into a wall. Waller falls to his knees after the impact and is then dragged out of the courtroom and into a holding cell. Deputy Lovingier is also heard asking, "Where is the taser?" After a few seconds, the judge remarked, "Ooh la la."
Oh, get up, get up, get up. Get on your feet. You don't turn on me. Boy, this is what you know, it's SWAT team. Get on your feet. I'm trying to talk. Get on your feet. Where's the taser? I can't move, man. Get on your feet. Oh, man. Get on your feet. My head's open, man. Shit, man. Man, don't turn on me. Don't give a shit who you are. You're not punking me. You're not turning on me. You're too charged, man. Keep going.
The reason for Deputy Lovingier's sudden and excessive use of force was because, according to Deputy Lovingier, Waller turned his head towards him. What happened was, when Lovingier suddenly took hold of Waller from behind by the belly chain, Waller instinctively turned his head back, who then yanked Waller violently by the chain, spun him around, and slammed him into a large glass window. Seeing this excessive use of force, the judge immediately served an excessive force grievance against Lovingier. After an internal investigation, Lovingier was suspended for 30 days. Let's head to a DUI case where lawyer Larry Foreman is up against Officer Shannon Oliver of the Eddyville Police Department. On August 21st, 2020, Officer Oliver arrested 66-year-old Mr. Raymond Hernandez for a DUI. However, during the court investigation, it was told that Officer Oliver forgot to note the proper details in the arrest report and had no DUI detection training for years. Let's see how lawyer Larry Foreman dealt with this cop.
I want to talk a little bit about your training. Something that hasn't really been brought up on direct examination. How many years have you been a police officer?
I started in October of 2007.
October of 2007, so about almost 16 and a half years now?
Close.
And in 2007, I assume that's when you went through the academy?
It was late 2007, early 2008 when I started. somewhere in that time. I don't remember exactly my training period before I went, but somewhere in there. Yeah.
Fair enough. It's been a long time.
Yeah.
And during that time, you learned how to conduct all sorts of investigations that you would use as tools when you become a police officer, correct?
Correct.
One of those tools is the detection and enforcement for individuals who might be operating a motor vehicle under the influence, right?
Yes.
And as you probably know, the agency that puts out the book is called the National Highway Traffic and Safety Administration.
Yes.
Does that ring a bell?
Yes.
Okay. Shorthand, they call it NHTSA, NHTSA. So NHTSA also puts out several follow-up trainings. Have you completed any of those since 2007 with regards to DUI detection and enforcement? Any refresher courses?
We do the training with the Intoxilizer every 2 years where we certify on that. The only required training that we have is just what we complete there at the Training Academy.
Okay, let's back up just for a minute. So the training you just mentioned, the training that you redo every 2 years, that only has to do with the Intoxilizer machine, correct?
Yes.
That's just how to operate it, make sure that you're certified, you're up to date on all the snuff.
Yes.
Right?
Yes.
It has nothing to do with going on the street and conducting field sobriety tests.
No.
Correct?
Correct.
Okay. So basically, what I'm hearing you say, and please correct me if I'm wrong, you have not had any supplemental DUI training since 2007, 2008.
No.
Okay. Now, during your training in 2007, 2008, one of the things that you were taught as a future police officer is how to write citations.
Yes.
Right? Citations are important because they document what happened with this particular case.
Yes.
Right? And so you were taught that they must be accurate,
Yes.
complete,
Yes.
and truthful.
Yes.
Right? Those are the 3 core principles.
Yes.
Because in the future, people would rely on the citation, on the information that you included in the citation, correct?
Correct.
Like here we are today. Mr. Wilson is relying on it, right?
Yes.
I'm relying on it. The jurors are relying on it. Right? So, and in this case, by the way, you did not have any type of body camera or in-car camera of any sort.
No.
And you did not complete any supplemental reports in this case.
No.
Officer Oliver accepts that he did not have any supplementary DUI training for 13 years, and he also did not write any supplemental report in this case, despite the fact that there were additional information about the incident that should have been recorded. Interestingly, in the incident report filed by the dispatch, there were 2 police officers at the arrest of Mr. Hernandez. But Officer Oliver doesn't seem to recall seeing any other cop at the crime scene.
So you may clarify, who is Mr. Seth Poole with the Lyon County Sheriff's Office that was dispatched en route and on site at the exact same time that you were at that location?
He works with he's a deputy with the Sheriff's Department. I don't know. I don't know why it was catted that he was on scene there, because when we were conducting this investigation, he wasn't there. So I don't know what the situation is with that. I can't say what the dispatchers put in their paperwork or whatnot. So I don't know if he showed up after the fact and assisted with the vehicle, possibly. I don't know.
If I may approach, Your Honor. Like I said, I apologize. I would have I just didn't expect to use this. I would have had another copy, but please correct me if I'm wrong. The dispatch time for Mr. Seth Poole with the Lyon County Sheriff's Office says 21st of August 20 at military time 21:26:17. Does that look right?
That he was dispatched en route at 21:26 the same time, and then on scene at 21:26. I mean,
About a second apart.
yeah, it doesn't really make any sense. I don't know why it.
And then on the next page, under your name, Shannon Oliver, Eddyville PD, dispatched en route, on scene, 1 minute, less than 60 seconds apart from Deputy Seth Poole.
Yeah, see, I don't know why this would be like that, because I was never dispatched to a call or en route, so it shouldn't have been documented that way. So I can't explain why the dispatchers documented it this way. I don't know, because it was just a routine traffic stop, so I would have never been dispatched. So I can't explain these times, and unless Deputy P. Poole would have been right there with me, it's impossible for him to be dispatched en route and on scene in the same minute, and he wasn't with me, so I can't explain why the dispatchers documented it that way.
When you are about to make a stop of a foreign vehicle, do you radio it in?
When I'm conducting a traffic stop, we'll advise dispatch that we're making a traffic stop, and we'll give them tag information and our location.
Did you do it in this case?
Yes.
So your only point of contention is you don't know why they wrote in Deputy Poole around the exact same time that you were on scene with Mr. Fernandez?
I don't know, because he was not there when I got out with him, so I don't know why they dispatched that. I don't know if they dispatched him at the time that I got a traffic stop and documented it that way. I really can't answer that for him. I don't know.
The presence of a second officer, Poole, has been mentioned multiple times in the arrest report, but the officer seems completely oblivious to it.
Just to re-verify to make sure I got my numbers right, sometimes I have trouble with military time, but 21:26:17 is 9:26, correct?
9:26 p.m., 17 seconds, yeah.
And on your citation, that's for Deputy Poole, right? Is it Poole? Is that what you call him?
Poole, yeah.
Poole.
Yeah.
I thought it was a typo, so I apologize, Seth. Poole. And the time on your citation is documented as 9:26 as the violation time.
That would have been, I would use that time for what time they had me, well, in this case, on scene or dispatched, which would technically be my stop time.
And it is your testimony here today that Deputy Poole was never present on scene?
If he was present there with the vehicle?
While you were there, excuse me, allow me to modify.
He may have been, but throughout my traffic stop, no.
You did not see him?
If he showed up at the end, possibly, I'm not sure, I don't remember, but no, I mean, he was not with me when I conducted the stop.
For the duration of the night, let's say from 9:26 until the arrest was made, you have no recollection, you don't remember whether or not Deputy Poole was with you or not?
When I conducted the traffic stop, he was not with me. If he showed up at a later point to deal with the vehicle, because sometimes we do that, if somebody needs to stand by with a vehicle or something, then we do that. And if that was the case, it may have happened, I don't recall.
You don't recall. Okay, that's what I was looking for. I'm not asking you to speculate. I'm asking you a question of whether you saw, heard, smelled Deputy Poole. Was he there or not there? What I'm hearing you say is you don't remember if he was or not. Is that correct?
Right, yeah. I mean,
Okay.
he may have showed up at the end. I don't remember.
You just don't remember?
Yeah.
Okay. But not at 9:26:17 as
Not
the
when I
CAD detail
initially
says.
conducted the traffic stop, because I was on patrol and saw the vehicle and stopped it there. So, I mean, he wasn't with me.
Can we have one more moment? Okay, so just for clarification, because I'm a little confused, and as I'm sure the jury is too. You testified that for the duration of the stop, you were the only officer on scene. So you conducted the entire investigation with Mr. Fernandez, stop to arrest by yourself, correct?
Yes.
There was nobody else?
No.
Okay.
The case was declared a mistrial, and a new jury was appointed for Mr. Hernandez's trial. All of this could have been avoided if Officer Oliver was more dutiful and had prepared the reports properly.
This time the motion from Mr. Foreman and Mr. Bates for hearing the testimony. I do declare this trial in this case. So thank you, members of the jury, for coming here today and being a part of this. Unfortunately, a resolution cannot be reached in this case. This case will need to be retried in front of a new jury. Thank you for your time.
Once you saw the barrel gun, you decided to pull the trigger and take who was on the other side of that window's life. Yes.
This is Officer Aaron Dean of Fort Worth PD being examined by the prosecution in a murder trial. In the wee hours of October 12, 2019, Officer Dean responded to a non-emergency call. The call was made by the neighbor of 28-year-old pre-medical student Atatiana Jefferson that Atatiana's house's front door was open. Officer Dean and Officer Darch can be seen responding to the call.
Put your hands up! Show me your hands!
Officer Dean did not wait a second for Atatiana to raise her hands up and shot her in the chest. As Atatiana was in her bedroom with her nephew, she had no way to know who Officer Dean was. For all she knew, he could be a burglar or an intruder, so her reaching out for her gun was well justified.
Well, as I said, I needed to see that person's hands, because the hands carry weapons. The hands are the threat to us. So I looked back after I got my light on, saw the silhouette again, and I was shouting at this time, shouting commands. Put up your hands. Show me your hands. Show me your hands. And as I started to get that second phrase out, show me your hands, I saw a silhouette. I was looking right down the barrel of a gun. And when I saw the barrel of that gun pointed at me, I fired a single shot from my duty weapon. And immediately had the flash from the muzzle reflecting off the window. And of course, as my weapon recoiled, the light was bouncing back in my face, so I couldn't see. When my vision cleared, then I observed the person that we now know as Miss Jefferson. I heard her scream and saw her fall like this. And I knew that I'd shot that person.
The jury reached a verdict after lengthy deliberation. The prosecution premised their case on the fact that Officer Dean fired his weapon even before he saw Atatiana holding the gun, whereas the defense claimed that Officer Dean had shot Atatiana in self-defense.
Everyone may be seated. Good afternoon. Mr. Presiding Juror, it is my understanding that the jury has reached a verdict.
After being pronounced guilty, the jury met again to decide the length of Officer Dean's sentence. The verdict was announced on December 19th, 2022.
Good afternoon. The jury has sent a note or given me notice that they have reached a verdict. Are both sides ready to receive the verdict?
State's ready, Your Honor.
The defense is ready, Judge.
All right. Y'all did fabulous when we did the guilt-innocence verdict, okay? Same rules apply. I don't know what this verdict is. Can't have any emotions, all right? Let's bring them in.
Judge, you're one point.
Everyone may be seated. Good afternoon. Juror number one, it's my understanding the jury has reached a verdict. Is that correct?
Correct.
Is it a unanimous verdict?
Yes, Your Honor.
Okay. If you hand it, please, to Deputy Nicholson. Mr. Dean. Verdict reads, we the jury, having found the defendant Aaron York Dean guilty beyond a reasonable doubt of the offense of manslaughter, assess his punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12 days. They do not assess a fine. And it is signed by the presiding juror. You may be seated. Thank you very much.
Next, we journey to Seminole County, Florida, where a courtroom drama is about to unfold. Judge Fred Schott is on the brink of a fiery confrontation with the prosecutor over an unjust arrest, which happened due to arresting Officer Michael Wagner's mistake. The individual at the center of this controversy is Lysette Gonzalez, accused of a DUI. However, it seems that Officer Wagner neglected to administer a breathalyzer test, yet arbitrarily noted in his report that Gonzalez tested above the legal limit of 0.8. On the basis of this DUI, 2 months later, Gonzalez was arrested and had her license suspended. The judge proceeds to ask the prosecutor and the cop, how was this license suspension valid, since the first DUI charge that started this case was not justified.
You have this other case for driving while license suspended, and
yes, I actually was, if I could be heard on that matter, I was going to ask.
Before you go there, I want to be enlightened. I didn't think your license got suspended for 6 months just for getting arrested for a DUI.
It was a mistake, admittedly, by Michael Wagner,
I know.
who testified to that today.
He caused her to have her driver's license suspended for at least a few months, and now get arrested.
Yes, he did, Your Honor.
For nothing.
Judge Schott is furious at Officer Wagner as he thinks that the officer committed perjury and inquires the public prosecutor if the government will take Officer Wagner up for perjury. The public prosecutor continues to defend the lies of Officer Wagner.
Are you going to no cross that case, or am I going to get mad at you today?
Perhaps you can get mad at me, Your Honor, but at this point, the only thing that we're willing
Did you
to
hear
do,
the
Your Honor,
uncontroverted testimony of this officer?
Your Honor,
Yeah.
regardless of...
Tell me your position.
Yes, Your Honor. The DMV is in charge of suspending licenses.
Yeah,
They
when
receive the ticket from
officers
the
lie to them,
Correct, Your Honor, and that's why patrons...
then I want you taking them up on perjury.
Your Honor.
Will you take them up for perjury?
He admitted it was a mistake, Your Honor.
No, but he lied. He lied on a sworn citation.
Your Honor.
Judge has had enough of it, and he dismisses Ms. Gonzalez's sentence sua sponte, which means he has enough reasons to believe that the jury was misled by the evidence turned in by Officer Wagner, and therefore he is overturning the jury's guilty verdict.
And that is not true.
I'm
The
dismissing.
state's position.
I'm dismissing.
You cannot summarily dismiss, Your Honor, without a motion for us to be able to respond to.
No, I'm dismissing the charge. You can appeal.
We will, Your Honor. Please provide us a written order.
No, I'm dismissing the charge.
So there will be no court minutes or whatsoever.
Sua sponte, based upon this record. And that case has the same record as this case. So take it up on appeal with him lying about it and getting
It's
her
not lying,
license
Your Honor,
suspended.
and I won't let that be said today. He admitted to the mistake today. patrons and people who have identifications and driver's license in the state.
Judge berates the public prosecutor for shamefully defending Officer Wagner and declares that the arrest for a DUI, as well as the subsequent arrest for driving on a suspended license, were illegal.
The state intends to amend the charge and proceed on a no valid.
I'm rescinding the sentence. I'm granting the JOA.
So you're granting it because you don't agree with the state's decision on the other charge?
I'm granting JOA in fairness.
In fairness, because you don't like the state's decision today, Your Honor, on the case?
No, you're not. No, I've reconsidered. I've reconsidered all of the testimony and the evidence. And you know, now that I consider,
would like to be heard on that
now that I
matter.
consider what Officer Wagner testified to and how many times he basically tripped over himself unnecessarily just to arrest this lady with no real probable cause. We should have had a suppression hearing. I'm granting the motion for JOA.
Then the state would like to be heard on that matter, Your Honor, as they're entitled to be heard.
Sure.
Judge not only dismisses the charge, but he also vows to bring Officer Wagner and others responsible for this gross misconduct back in court where they will be held accountable.
Today we've proven, as Your Honor initially indicated, until such time as the state was not able to tell you why we're proceeding on the charge that we were proceeding on, the state intended to amend that to either a civil infraction and or a no valid, but the state needed time and intended to do that. However, in this particular case, there was ample testimony as to the fact that the defendant's own statement that she was in possession of alcohol and she drank it. There was testimony uncontroverted from the defendant that was in fact alcohol and she normally doesn't. This is again evidence, direct evidence, and not circumstantial evidence. Furthermore, there was bad decision making, there was balance, there was sway issues, and everything else.
JOA for the defendant. You're done. They still have this other criminal charge. I'm not dismissing that. The DeWillis, we're going to go full bore. We'll get DMV people in here. We'll get Officer Wagner back here, and we'll find out why your license was suspended or if somebody broke the law to cause your license to be suspended. And that's the route you wanted to go.
No, Your Honor, that's not the route.
Is that motion? JOA is granted.
The judge criticizes the criminal mistake of the cop, Michael Wagner, and orders the motion to be dismissed. Gonzalez was released soon afterward. Next up, we have Prosecutor Larry Foreman, who is interrogating the arresting officer in charge of the DUI case against Mr. Dawson. The cop admits under oath that he poured out the alcohol found at the scene, thereby destroying a key proof of Mr. Dawson's wrongdoing. This does not go well with the prosecutor, who then proceeds to school the cop on what the law says.
Okay, so I want to talk about, very briefly, about two things. Number one, I want to talk about the alcohol that you found in the Wendy's cup in the car. Okay?
Yes, sir.
You found it after you had placed Mr. Dawson in handcuffs, correct?
That's correct.
He was already under arrest before you found that cup.
That's correct.
You testified on direct examination that you sniffed the contents and determined it to be alcohol, correct?
It had the odor of an alcoholic beverage.
It had the odor of an alcoholic beverage.
Yes.
Did you bring it with you to court today?
No.
Did you preserve it in the evidence locker at the Richmond Police Department?
No, I poured it out.
Are you admitting to this jury that you committed the offense of destruction of evidence?
The public prosecutor seems shocked as he realizes that the officer had admitted to a felony under oath in the courtroom. The cop also realizes his mistake and takes a pause before carefully choosing his next words so that he does not incriminate himself again.
I did pour out the liquid that was in the cup. I had no plans on collecting it. It's not our common procedure or policy that we do collect those at the Richmond Police Department. So I smelled what I believe to be the odor of an alcoholic beverage, and based on Mr. Dawson's statements as well,
And I poured it out, yes, sir.
When the lawyer asks the cop what he did when he saw the alcoholic beverage in Mr. Dawson's car, the cop naively tells the court that he poured it out.
Are you aware that destruction of evidence is a Class D felony in Kentucky, carrying up to 5 years in prison and a $10,000 fine?
Yes, sir.
Let's talk about the marijuana. You searched the vehicle and you did not find any marijuana, otherwise you would have charged Mr. Dotson with possession of marijuana, right?
That's correct.
The defendant was released following this trial, and the cop learned a lesson on how not to talk in court.
Yo, you guys are gonna get so much love for this.
This is Ty Warenka being handcuffed by Officer Denny Carter. On June 11th, 2022, Ty was leaving his work on Capitol in Maine, Boise, Idaho, when he saw two officers, Officer Carter and Officer Westendorf, investigating a car accident at the pay station of the lot. The parking lot employee asked Ty to move along, which he did, and later came back with his phone to film the two officers.
I'm leaving right now. I'm trying to leave.
This gentleman's already asked you to leave once. You came back around.
He asked me to leave the garage, which I left.
No, you're here in the garage. You can't have left the garage.
He asked me to keep driving, and I kept driving.
Okay.
He didn't say don't come back.
You want this gentleman to leave?
Yes, please. I'm trying to leave. What do you think I'm doing? You just stopped me.
Interfere. Let me make this clear. I want to make it super clear.
So sure, tell me what I was interfering with.
Take that out of my
Oh, okay. Whoa. I'm not resisting.
It is obvious that Ty does not move from his place, nor does he try to obstruct Officer Carter's view. He is just filming the incident on his phone because that is his constitutionally protected right.
I'm not resisting.
You're under arrest.
All right.
Don't put that up in my face and try to assault me.
I wasn't trying to assault you, but
That's what it looked like to me.
I'm glad your camera's on.
Yeah. I'm glad you're saying what you're doing.
Oh my gosh, you guys. So what are you arresting me for?
Resisting and obstructing.
Resisting and obstructing?
Yeah.
Okay. Well, what was I obstructing?
My investigation.
How was I obstructing your investigation?
Can you try to block my view?
Block your view from what? My face?
Camera? I'm trying to have a conversation with you.
Tell me. What was I blocking your view from?
Officer Carter's lies are all but obvious from this footage. He not only knocks Ty's phone down, but also shoves him against the wall. Ty did not seem to pose any threat or obstruct the officer, but Officer Carter still chose to hit him and arrest him on frivolous charges.
See how you guys are gonna get so much love for this. Carter? What's Ganondorf? Perfect. The power's gone to your head, bud. The power's gone way to your head.
Stand up.
Yep. Stand up. The power's gone majorly to your head. You're gonna shove me in the face after holding my camera up?
No, for blocking my view and obstructing
Blocking your view of what? Of my face? See, you can't, Carter, you got yourself fucked up, dude. Okay. Blocking your view. What was I blocking his view of, Westendorf? You got nothing? I bet not. That's a battery. You put it in electronic devices.
Slide this one. Thank you.
You better control your partner, my friend.
On the passenger side, is that right?
Yep.
Oh my gosh, you guys.
Go to that side, grab it up.
Oh my gosh. shoving me in the face for what? Holding the camera up? That's totally interfering with the investigation when I was kidding. How's that happen?
I'm pretty sure it turned off his phone. I can't tell though. It's up there on the dash. What do we need to finish up for them? I can't. I took a picture of the insurance. So.
Okay, so here's this for.
That's for the car. Okay. All right. I've got the stuff for the other car.
But it seems like Officer Westendorf isn't any better either. He slams the door in Ty's face, who is obviously pissed at being falsely arrested.
Don't grab my cash, you can grab my ID.
I'm gonna take the whole thing.
Okay, I know how you guys work. Yeah, go ahead.
I'm gonna take the whole thing. I'm taking charge.
Dude, get a life. Come on. How could you not take my ID?
Here.
Very first
Do you
thing.
want me to put it in your pocket? Or you gonna put it back
I
in
don't
your
know. I'm scared of what you might do, so I'm gonna put it in my pocket.
Someone is
You guys picked the wrong one. That's crazy. Our police just feel like they can intimidate people and
Ty, you have the right to remain silent. I would request that you do so.
Ty was taken to the police station and charged with obstruction of a police officer. Later in October, these charges were dropped. But now, Ty has filed a federal lawsuit against the two officers and Boise City for false arrest and violation of civil rights.
It is frightening to see dirty cops committing grave crimes, and unfortunately, many times these dirty cops also get away with it. These are not one-off instances, as the series of unfortunate events highlights serious lapses in police training protocols. As long as dirty cops keep hiding behind qualified immunity, citizens will continue to feel unsafe around cops. If you enjoyed this video, let me know in the comment section and don't forget to subscribe. Goodbye!